Hi and welcome to the show. Most people don't know what to expect or do when faced with a legal dispute, be that in labor, matrimonial, property, debt counseling, or more. We aim to give the viewers a bigger and a broader understanding of the law in South Africa to make sure the vulnerable are not taken advantage of. In this show, we address specific questions by you, the viewers, via our email and WhatsApp platform. So don't forget to send us your questions to the email address and the WhatsApp number that will be provided at the end of the show. I'm your host, Fazloodien, and you're watching the Fazlaw show on Cape Town TV. According to an article in the Sowetan Live, only 67.5% of tenants who pay below 3,000 Rand per month remain in good standing. That means 23.5% of those tenants found themselves in arrears and possibly being evicted. Some of the tenants found themselves 6 months in arrears with a resulting financial loss for the landlord. Even though landlords afforded tenants a 3-month rental relief during 2020 lockdown, that was short-lived as most of these tenants found themselves without an income or a job. The article further claims that the residential rental tenants continue to downscale and the number of tenants in good standing for a payment performance perspective are still not back to pre-COVID levels. The good news in the article is that the 7,000 Rand to 12,000 Rand rental per month category showed growth of 23.3% with 84.37% of tenants in good standing and only 4.86% unable to make any payment at all. It appears from the statistics that the negative effect of landlord versus tenants is here to stay, and disputes are still having a negative impact on communities trying to live a good life. However, there is hope, and the newly amended laws appears to be a solution, or does it? With me today is our guest expert, Ismail Muhammad, a litigation attorney who is a director and who has a passion for mediation and settling disputes out of court, but is not afraid to fight it out in court in the interest of his client. Ismail is a director at Muhammad and Leon Incorporated and specialise in family law, evictions, debt recovery, dispute resolution, and general civil litigation. Ismail, welcome for being on the show.
Thank you for having me, Fazloodien.
So I'm going to jump into the questions, all just with regards to general disputes that we find in our practice. So the question that I've got for you is, when people lose their jobs, the usual result is that they go in arrears with their home loans, and the bad result is that the bank wants to foreclose. The property goes on auction, and before you know it, a new owner who bought it on auction, he's now busy with evicting the seller. How do you prevent that from taking place?
Well, Fazloodien, I'm happy that you asked the question as to how do you prevent that, because that's a different question to how do you fight that. And to just quickly touch on fighting it is essentially a losing battle because you have a new owner in your house. Yeah. But when we look at prevention, there are a few ways we can do that. Number one is, in today's climate, it's always a good idea for homeowners, employees to take some sort of income protection, some sort of insurance policy that pays out in the event of them being unable to pay their mortgage bond. So at least you have some buffer, which prevents you from falling into arrears, and therefore you are able to continue your payments until hopefully you find a new source of income. Second to that, if you are finding yourself in this issue, then it's best to approach your bank. Speak to your bank, ask your bank, can we reduce my monthly installment? Can you give me some sort of a payment holiday? Because what you need to do is you need to buy yourself time to be able to get a new form of income, because the last thing you want to do is bury your head in the sand and the bank doesn't know what's going on. All they see is there's no money coming in. Yeah. And now they execute against you. You want to have some communication at all times.
Keep that communication open.
100%.
Approach your bank and also see if your insurance covers the payment holidays.
100%, correct.
Okay. So the next question is, now you find tenants paying a deposit. The landlord is over the moon, he's got his deposit, he's got his first month rental, and then before you know it, the tenant had bad intentions. So after paying, he now says he doesn't have any more rental for the landlord. He's a nightmare tenant. How do you avoid that?
Okay, again, we're looking at avoidance. You have to do some homework on your tenants in the beginning to try to determine what the future holds. Now, nobody can for certain say what the future holds, and there are no guarantees. But you have to do as much as possible. So what you want to do is you want to vet your tenants. Don't simply look at, oh, he's brought me a deposit of 3 or 4 months worth of money, and I'm taking this and I'm covered. No, you want to vet your tenants. You want to do credit checks on your tenants. You want to get referrals from your tenants. So you want to find out from previous landlords, what kind of tenant was this? Why did they indeed leave their previous premises? Because the lease ended, because they weren't paying. You want to do this homework. You can approach agents out there who will do procurements for you. You can approach attorneys who can do credit checking for you. It is going to cost you some money, but rather spend some money now, get a good tenant, than spend no money now and end up spending a lot of money on litigation a few months down the line.
So in a nutshell, make sure the income and expenses is good, yes, and there's affordability, so that you know your tenant can afford to pay your rent at the end of the month.
Affordability, income and expenses are good, and you want references.
Okay. Next question. Your tenant finds himself being abused by a landlord to the sense that he's not interested in the living conditions of the premises. All he wants is his rent at the end of the month. Who does one go to for help? Where can the tenant go to?
Okay. In a case like this, there are two branches that your tenant can approach. On the one hand, your tenant can approach an attorney who can take a matter to court. Because if the living conditions are not up to standard, then your landlord is in breach of the Rental Housing Act. Yeah. And that can be enforced through the courts. However, there's also a rental housing tribunal, which is free of charge, and both landlords and tenants can approach them with complaints against the other party, and they will try to bring that to resolve.
Okay, perfect. Now, another question. There's this perception, and I want us to debunk that perception. Is PI a protection for unlawful occupiers to continue their occupation until the city provides an alternative accommodation?
Simple answer, no. PI is not a protection. People believe that PI is a protection simply because of the process. PI is law. It is an act that has been passed by our government. It's signed into law. It's been around for many years. It sets out the procedure that a landlord needs to follow in order to evict a tenant. One of these procedures is, does the city have alternative accommodation? It's not the city must provide alternative accommodation. It's can the city provide. So the city will give you a report on this. But at the end of the day, the procedure will set out how a tenant is evicted. It might take some time because you have to go through the process, but it's not going to protect the tenant to live there forever. I mean, just to quickly elaborate on that, in the industry, you find a lot of people walking around using the term squatters' rights. There are no such thing as squatters' rights. There never has been. PI is simply a procedure which might take some time,
okay,
but it's not a protection.
Got it, thanks. So that brings us to the end of the ad break. We're going for an ad break, and I ask you to keep on watching, and we'll definitely get to your answers of your questions and see you after the break. Thank you. Welcome back to the show. In the first segment, we looked at the statistics of evictions, highlighted by an article from the Sowetan Live, and got to know our guest legal expert, attorney Ishmael Mohammed. Then towards the end of the first segment, we had a short discussion on usual disputes and the legal ramifications when a landlord or a tenant don't abide by the law. I'm your host, Fazloodien Abrams, and you're watching the Fazlaw Show. Ishmael, I just want to focus on the efficacy of the current law. And I want to make sure that our viewers understand the words. So before we really go into more questions, can you explain to me that particular word? So in other words, what does the efficacy mean with regards to PI? And what does it mean to the layman more particularly? And how does it apply to various lease agreements?
Okay, so when we come to the term efficacy, what we're looking at is how effective is the law in solving disputes between landlords and tenants. Now, when we're specifically speaking about PI, we are speaking about evictions. So is the law effective in having people evicted?
Okay.
From this point, my answer is a bit of a yes and a bit of a no. Now, the reason I say that is when I say it's a bit of a yes, it's because yes, you will end up with an eviction order.
Okay.
Because when your landlord approaches the court looks at certain requirements. We don't really have the time to go into what all these requirements are, but the court will look at these requirements and then make a call whether it's going to or not going to grant this eviction order. So in that form, it is definitely effective.
Okay.
Where it loses some of its efficacy is because it is a broad stroke. So every occupier out there, whether it's somebody who has invaded land or whether it's somebody who has stopped paying rental after a few years, the PI Act looks at them as the same. The same procedure needs to be followed. The same everything needs to be done. And that's where the law can be found to be a bit lacking. Because a municipality versus a private owner, there's different prejudice that needs to be looked at.
So which laws governs the rental housing agreements, commercial rental agreements, and when was it written?
Okay, at this point in time, we have two major pieces of legislation, and we have the common law. But looking at the legislation, we have the Rental Housing Act, and we have the Consumer Protection Act. The Rental Housing Act only applies to residential lettings. So you have to have somebody physically living in the property, where the Consumer Protection Act applies to residential as well as commercial. The CPA only came into effect a few years ago. It really only started being used in 2011. Prior to that, commercial leases fell under the common law. Now, the common law is a law that's been created over the last 100 years with different cases and so on and so on. So those are your three major sources of law when it comes to leases.
I want to switch over to the questions that were posed by the viewers. Right. So in essence, how long does an eviction take? But in short, how long does it take to get an eviction order?
Very difficult to answer that question, but I can say nothing under 3 months.
Is it better to mediate an eviction matter or go to court?
100% better at mediate, because as I say, an eviction application is not going to take less than 3 months. A mediation can be done in a day, maybe even less.
What is an unlawful occupier in terms of PI?
An unlawful occupier is anybody that either never had a right to occupation or has lost their right to occupation. So I give you two examples. Somebody who invades land, never had a right to occupation, and is therefore deemed an unlawful occupier. Someone who had a lease which has been cancelled, lost their right to occupation, and is therefore an unlawful occupier.
Okay. So here's a question. I'm late with my rent and my landlord has cut the electricity. What do I do?
Here you have two options available to you. Number one, you can approach a rental tribunal and they can force the landlord through a spoliation order to turn the electricity back on or any service that's been cut. Second to that, you can approach an attorney who can approach a court for the same order. The rental tribunal can do it, but they are going to take longer. An attorney can be much more effective. They can have an order for you on the same day.
Okay. The roof is leaking and the landlord don't want to fix that. Can I use the rent to fix the roof, and what's the procedure to follow?
You can do that, yes, but it's not immediate. You can't simply see a leak and decide you're going to fix this and take the rental. You have to approach your landlord. You have to give the landlord opportunity to fix the roof and keep the place in a living condition. If the landlord outright refuses, then yes, you can do a set-off.
Okay. My daughter is the owner of the land and she lives abroad. I am in control of the property. Can I be a party to the eviction order or application?
Yes, you can. And the reason for that is in terms of the PI Act, it specifically says the owner or person in control of the property may launch an eviction application. So if you have something formal, a power of attorney or some sort of a mandate, then yes, you can be that applicant.
Okay. And then I received a notice of breach. How long do I have to remedy the breach, and what does breach of contract mean?
Okay, breach of contract simply means you haven't done something you're supposed to do. The classic example would be the tenant did not pay the rental. Now, in a situation like this, we now need to look at our two major conditions of legislation. The Rental Housing Act says you may send a notice calling on your tenant to pay. If they don't pay, you may send a summons or you may claim the money. That notice can be at a reasonable time. The Consumer Protection Act, however, says your notice must be 20 business days. Wow. If they haven't paid within 20 business days, you may now cancel the lease and they become an unlawful occupier.
Okay. Let's see. I was told to occupy land by a person who's not the owner of the land. What can happen to that person?
That person gets into quite a lot of trouble because, number one, they have taken something upon themselves that doesn't belong to them. They've taken a benefit out of this. That can be both a civil claim for damages that the actual real owner has suffered, and it can also be a criminal charge depending on how far this situation has actually gone.
Okay. Thank you. That brings us to the end of the second segment of the show. Keep watching for more answers to your questions, and I'll see you after the break. Welcome back to the show. In the second segment, we started with a recap on the first segment. We discussed the efficacy of the current laws pertaining to evictions and if those laws need to change. Towards the end of the second segment, we had a question and answer session with our guest legal expert attorney, Ismail Mohammed. I'm your host, Fazloodien Abrams, and you're watching the Fazlaw show on Cape Town TV. Ismail, I want to get back to the questions that was asked by the viewers. The first question is, can I be evicted by police without a court order?
No. There is no circumstances that you can be evicted without a court order, whether it's the police or any other institution or private body. There must be a court order.
What is a city report and why is it needed during an eviction order?
The city report is a constitutional mandate that the city holds, where the Constitution says that all persons have the right to adequate housing. When you are being evicted from any premises that you may occupy, the city has to give a report to say they can or cannot accommodate you. I just want to touch on what we said in the first segment. This report is not a whether or not you can be evicted. It's simply a whether or not the city can accommodate you. The city may come along and say in the report, we have no alternative accommodation available. That doesn't mean the court's not going to grant the order.
So the order will be granted. It's just about the time frames as to when the eviction must be executed.
Correct.
Right. It says here that I've evicted all the tenants living in the house and those living in the yard. The structures, can it be demolished and removed, and how?
Yes. Your eviction order, your PI order that's granted by the court may grant in that order all structures to be demolished and disposed of.
The sheriff has been ordered to evict the occupants and they've been threatened by them. Can the sheriff ask the police for assistance to evict the people?
Yes, the sheriff is fully entitled to ask for that assistance. And what I have found recently, a lot of the sheriffs ask for that assistance even without a threat having been made, just to avoid any such threat coming in the future.
Okay. When can an urgent eviction be applied for?
An urgent eviction is a very, very stringent aspect in law and can only be applied for when there's imminent danger or threat, either to the landlord or the landlord's property. Okay. Then you may get an urgent eviction.
Okay. So this question is, what is an organ of state and when can such a body apply for an eviction application?
Okay, an organ of state is any institution which carries out some sort of administrative function of the state. For example, when we speak about PI, we are looking at the municipalities. Now, a municipality owns several tracts of land within its jurisdiction, and if there are invaders on the land, or even if the city had previously letted that land out and that right to occupation had come to an end, the city, like any other private or public institution, may approach the court for an eviction application under PI.
Next question, in terms of PI, what is a private prosecution and what are the requirements to do so?
Okay, a private prosecution it falls within the ambit of PI in so much as there is a certain unlawful or illegal aspect to pay. If a landlord were to do some sort of illegal activity by, for example, evicting a tenant without a court order, it's deemed to be illegal, and the tenant can approach the police to have the landlord prosecuted. If the police refuse to take that case on, the individual may then start a private prosecution process.
Okay.
Right? There are some technicalities to that which we don't have time to get into.
Yeah.
But as I say, there must be illegal activity, and then there may be a private prosecution.
Next question. What are the consequences or the penalty for someone who prevents an eviction from being carried out?
Okay, that is, again, also a very difficult thing for someone to do, because there is a court order. For someone to try to stop a court order from being carried out can be deemed contempt of court. And if you find yourself in contempt of court, you may find yourself incarcerated, as our ex-president Jacob Zuma found.
Sure.
So do not, under any circumstance, try to avoid a court order.
You used the word earlier in the show, it's spoliation. What does that mean, and what does it cost?
Okay, spoliation in a nutshell is to get back something that you've lost. So, for example, as we said earlier, the landlord's cut off electricity. The tenant is entitled to electricity. You may now spoliate, which is the legal term for the court saying to the landlord, turn the electricity back on. How much does a spoliation application cost? That's going to depend on how urgent it's going to be. Something like electricity might be brought 2-3 days later. It's going to obviously cost some money. If, for example, the landlord were to remove the door,
Sure.
and now the place is exposed and there's some danger or a lot of danger to the tenants, that application needs to be brought immediately, and based on that urgency, the cost is going to be substantially more.
Okay, thank you, Ishmael. That brings us to the end of the question and answer session on the show. So I want to thank you, and you've been an amazing guest and even a better expert, and we hope to see you soon again.
I hope to be here again soon. Thank you.
That brings us to the end of the show. And don't forget to send us your questions via the platform. Our email address is info@fazlaw.co.za. That's info@fazlaw.co.za, or our WhatsApp, which is 082-495-8989. That is our WhatsApp number. Send us your questions, and our next episode we're looking at would be, what are your rights regarding mandatory evictions? So stay tuned, and we'll see you at the next episode. Thank you very much. My name is Fazloodien Abrams, and you're watching The Fazlaw Show.